Are there any other votes? Announce the results.
Ayes 78, noes 32.
The bill is passed.
Assembly 9995, Calendar 850. Ms. Weinstein, an act to amend the civil practice law and rules.
An explanation has been requested.
Yes, thank you, Mr. McKibben. This is another bill that came out
One
of...
second, Ms. Weinstein. Mr. Morelli.
Thank you, Mr. Speaker. Let me just try to give people a sense, because obviously the night is growing long and people are obviously curious about how much longer we'll be here. We have a Codes Committee, which I'm about to call momentarily. We also have a Ways and Means Committee meeting, which needs to be done tonight. So we're going to be here for a little while longer. We have two bills that I've called up. We're going to try to condense some bills on the A calendar. So I apologize, folks. We're going to be here a little longer because we have to get through Ways and Means. So with that, Mr. Speaker, if you please call members of the Codes Committee, the Speaker's conference room. As soon as that is completed and Mr. Lenthal finishes his business, we'll call Ways and Means, and then we'll keep working through it until then. Thank you, sir.
Thank you. Codes to the Speaker's conference room. Apologies, Ms. Weinstein.
Yes, so, Mr. McKibben, as I was saying, this is another one of the bills that grew out of the hearing we held and is designed to promote fairness to consumers who often are held to onerous venue provisions and contracts for consumer goods. So very simply what this bill does is it preserves the existing right of consumers to use the venue provisions. That's, for those who don't know, the place where the court action begins in consumer contracts, to the what's currently in Article 5 of the CPLR, to the place that the place of trial can be in the county where the consumer resides, even if the contract says you have to go to Oshkosh, Chemung County, and you're from the Bronx. So it's a very simple bill that's consistent with our current rules in the CPLR.
Will the sponsor yield for just a couple of questions?
Yes, certainly.
Well, so let me start with the basics as we're going forward tonight. Yes, you'd make the point that already under CPLR, under one of the proper places for venue would be where the plaintiff resides. So really under the default rules that we have, again, if you have a consumer who goes and lives in Buffalo and you have a defendant from, let's say, Suffolk County, under the default rules we have, you can commence that action in Buffalo because venue would be proper place where the plaintiff resides, correct? Right. And the purpose behind this bill is the problem whereby the company or the contract may bind you to a certain venue which may be inconvenient to you. I think you may use an example whereby a consumer had a snowboard in Suffolk County but had a venue clause in Greene County, which certainly for a consumer is quite inconvenient to go up to Greene County in order to go and have your case adjudicated, correct?
Correct, and these determined designated venues so often are just in boilerplate in a contract. Consumer often doesn't even know that it exists. It's buried somewhere in the contract, and it just restores back to the consumer what would be the ordinary place of venue in a face-to-face arm's length contract.
Yeah, just one group actually contacted me with a concern about it. And let's say, for example, you had gone and bought an automobile in, let's say, Babylon, New York. There's a lot of automobile dealers there. And you have the car, and maybe a few months later you decide to move up to Buffalo in that instance. And what the auto dealer may say, listen, we sell cars in Babylon. We're not expecting to go and people throughout the rest of the state to go and buy our cars. We deal mostly with people in maybe Suffolk County, Nassau County, Queens. So we'll put in the agreement that venue would rely in Suffolk County because that's where the person bought the car. And again, you have a situation whereby the person bought the car in Suffolk, may have moved upstate, and the auto dealers say, well, it's unfair to drag us upstate because we never contemplated going 400 miles away. We feel the car was here. You came to us to buy the car here. Why should we now be forced to litigate this 400 miles away rather than where the car was bought? Just a concern.
This is consistent with current law under situations like you present. The court can, the defendant can make a motion that the venue of the plaintiff is where the plaintiff began the action is inconvenient, and the court could find that it should be at the defendant's, the venue should be at the defendant's place of business in this circumstance.
Okay, thank you.
Read the last section.
This act shall take effect on the 30th day.
The clerk will record the vote. quickly.
Yeah, so we're at 77.
Are there any other votes? Announce the results.
Ayes 77, noes 18.
The bill is passed.
Senate 2448A, Rules Report Number 222, Senator Farley, an act to amend the general municipal law.
Explanation's been requested.
Mr. Speaker, this bill amends the general municipal law to require that notice be given to retirees when there's a change in their health insurance benefits.
Ms. Corwin.
Thank you, Mr. Speaker. Would the sponsor yield?
Yes, Mr. Speaker.
Sponsor yields.
Thank you, John. Yes, my understanding of the bill here is that they must give 90 days notice when there is a proposed change to the contract or an amendment to it. However, if it's if the contract is part of a union negotiation, that they would not be required to make that notification until the contract is binding.
That is correct.
Okay, so I guess my question is, in one instance we're doing it when it's proposed, and in another instance we're saying when it's going to go into effect. So what's the difference? Like, why would
The
we handle
difference is
differently?
we do not want to interfere with contractual negotiations between a collective bargaining agent and a municipality. But where there is no collective bargaining agent, then we want the municipality to give the retirees a sufficient amount of time so that they can plan in advance for any changes that will occur to their health benefits.
Okay, sure. Now, you specify 90 days in the bill. Obviously, a lot of times these health plan changes and so on come about as a result of a budget negotiation. Is it reasonable to expect that we'd have 90 days advance notice in terms of being able to make this offer, since they're going to be negotiating it as part of a budget?
Well, if it's part of a budget, yes, I think it would be reasonable. We have found in the past circumstances where retirees are given notice of potential changes. They then come in and make suggestions on better ways for the municipality to save money on the very issues that they're discussing. So the idea here is, one, to give retirees the opportunity to plan for changes, and two, perhaps involve them so that they can make suggestions as to how things can be changed so the municipality could save the same amount of money, but not to the detriment of the retirees.
Sure, but I can't help but think of our own situation here at the state level. We engage in budget negotiations, and we can't even get the bills out with 3 days' notice. I'm not sure how we can expect someone to come out with 90 days' notice and be able to implement that without creating some havoc, if you will.
Well, but changes take a while to incur anyway. I mean, if you're dealing with a health insurer, it takes a while to make the changes that you want to make. So I think there's plenty of time between the time that the municipality makes a determination that they want to make these changes and the time they actually put them into effect.
Another issue that's been raised by some is regarding the website, and this is more of a logistics idea. Many small municipalities may have a website, but they don't really actively maintain it very well. The bill very specifically requires that the information be made available on the website. What happens if the municipality doesn't have an active website?
Actually, the bill gives the municipalities an option of either giving the notice in writing with a full text enclosed, or giving a notice in writing with the general terms and then specifying where the covered retirees can find the full text, which would include a website. So if a municipality does not want to use a website, they could just send the full text out to the retirees.
I see. Okay, yes, that would be very helpful. Again, I would just say that our Conference of Mayors has written in opposition. They make the point that 90 days advance notice may not be possible, again, because it would be part of budget negotiations, and oftentimes, as we've experienced here at the state level, that these negotiations go right up to the last minute, but also regarding the website as well. So you may want to just consider the 90-day rule in a modification for the bill.
I would suggest that we try it. If 90 days proves to be a difficulty, we can always come back next year and shorten the time period. But I think we have to give it an opportunity to work. We want to make sure that our retirees, especially in this day and age, have enough time to make changes in their lifestyle or in their budgets to accommodate any changes in their health insurance.
And I apologize, but is there any penalty if they don't abide by these?
No, this is just a legal mandate without a penalty.
I see. Great. Thank you very much. Thank you, Mr. Speaker.
Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
Yes, Mr. Speaker.
The sponsor yields.
I appreciate your desire to give as much notice as possible to retirees. The question I had was a practical one. If a municipality has an annual contract with a health insurance provider and that contract expires within the 90-day period, what is the municipality to do?
I would suggest that requires a little bit of planning on behalf of the municipality, 90 days before the expiration. I'm sure they're going to be making some determinations themselves as to how they're going to be handling that health insurance plan. And at that point, they would give notice to the retirees.
I understand that we don't have this issue if they can reach agreement with the employee organization to change health care providers more than 90 days before the expiration of the plan. But if they don't reach an agreement within that 90 days, what happens?
If there is a discussion with a collective bargaining agent, notice only has to be given when the contract is binding. If there's no collective bargaining agent, then there's this second process of 90 days notice.
So if there's collective bargaining, there could be no notice?
The notice would have to be given at the time the contract is binding, but there's no requirement for 90 days notice.
And if a municipality without a collective bargaining agreement doesn't reach agreement with its governing board more than 90 days before the expiration of a contract, what happens?
I think in that case they would have to find a way to extend the existing benefits so that they could give 90 days notice, or they have to anticipate 90 days before the expiration of their policy
And
give notice to the retirees of the status of what the status of their insurance will be in 90 days.
are you aware of any health insurance companies that will give you a extension for 30, 60, or 90 days of an existing policy upon its renewal?
I am not an expert in municipal insurance, but I would suggest that most municipalities are planning more than 90 days in advance of their expiration as to how they're going to cover all of their employees. And they will be given notice more than 90 days or 90 days in advance so that they can be planning, and they will just have to give notice to the retirees at the same time they receive notice of a change in their policy.
Thank you, Mr. Abernathy. On the bill,
On the bill.
I certainly appreciate the desire to give retirees as much notice as possible. But unfortunately, in the field, a lot of times you have health care contracts that cover retirees that are renewed on an annual basis. And it's not within the ability of a municipality, particularly a smaller municipality, to say, yeah, we know our health insurance policy expires on December 1st, but we want a 3-month extension because we haven't reached agreement on our new budget until December 1st. And our new budget includes a change in health care. And so while I appreciate the desire of the sponsor, I'm not sure that the 90 days actually works, particularly with smaller municipalities where they are not in a position to get a 30-day or 90-day extension, and they don't adopt their budgets 90 days in advance. And certainly for those of us who have come from county government, we have a time frame. My county doesn't normally adopt the budget 90 days in advance. The cities in my municipalities don't. My towns don't adopt budgets 90 days prior to the end of the fiscal year. We in the state legislature, we don't even adopt it on time. So while it's a great idea, in reality, it's going to create a lot of problems for all of our local municipalities. Thank you, Mr. Speaker.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 79, noes 22.
The bill is passed. Mr. Morelli.
Thank you, Mr. Speaker. We've already advanced the A calendar. I'd like to take up the A calendar first by going to page 3 of that calendar and taking up Assembly Resolution 1571 by Mr. Simbrowitz.
Clerk will read.
Resolution number 1571, rules at the request of Mr. Simbrowitz. Legislative resolution memorializing Governor Andrew M. Cuomo to proclaim June 15, 2016 as Elder Abuse Awareness Day in the state of New York.
On the resolution, all those in favor say aye. All opposed? The resolution passes.
The bill for next year. I just don't. Okay, good. Yeah.
Assembly 295, Rules Report Number 385, Mr. Abenante, an act to amend the election law.
Bill is laid aside.
Assembly 2942B, Rules Report 386, Mr. Sepulveda, an act to amend the social services law.
Bill is laid aside.
Assembly 2948A, Rules Report 387, Mr. Hevesy, an act to amend the workers' compensation law.
Read the last section.
This act shall take effect on the 120th day.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 99, noes 0.
The bill is passed. Mr. Morelli.
Yes, thank you, Mr. Speaker. And what passes for progress here, we have concluded the Committee on Codes, and it's now time for the Committee on Ways and Means. Mr. Farrell awaits members of Ways and Means in the Speaker's conference room.
Ways and Means is called in the Speaker's conference room.
Assembly 3504, Rules Report 388, Mr. Wright, an act to amend the workers' compensation law.
Bill is laid aside.
Assembly 5643B, Rules Report 389, Mr. Dendecker, an act to amend the vehicle and traffic law.
Read the last section. On a motion by Mr. Dendecker, the Senate bill is before the House. The Senate bill is advanced. Read the last section.
This act shall take effect on the 90th day.
Clerk will record the vote.